Hi, this is Larry McGee. We're back for our second part in our series on the buyer listing contract. We're going to start this series with Section 5 and go through Section 7. These are fairly intense parts of the contract, so we'll take a little time here to check out 5, 6, and 7. 5 speaks to brokerage duties. Brokerage firm acting through broker is either a transaction broker or buyer's agent must perform the following uniform duties when working with the buyer. Now, all of these from 5.1 down to 5.8 talk about the things that we have to do in all cases. When we get to 6, we'll be talking about the additional duties of the buyer's agent, which in most cases, agents at the Berkshire Group do represent their buyer. So starting here at 5.1, we're certainly going to have to exercise reasonable skill and care, not limited to the following: performing the terms of any written or oral agreement with the buyer. I caution everyone to be very careful here with the term oral agreement. If you say something off the cuff about what you might do on behalf of your buyer, you might find yourself obligated to that based on the terms of this contract. So be very careful what you say when you're showing properties or helping people negotiate an offer. Presenting all offers to and from buyer in a timely manner. Absolutely. Even if the buyer is already a party to a contract, they certainly have the right to go make another offer if they think they can improve their position. Disclosing to buyer adverse material facts. Anything we know about a property, we should tell them. If we don't know about it, obviously, we don't have to tell them. Advising buyer regarding the transaction and advising buyer to obtain expert advice as to material matters. Well, everyone, I'm a fairly skilled broker, but I'm not a very good building inspector. So I advise all of my clients that we're going to get inspections. We want independent inspections. We want people who are skilled at examining property, whether it's a basic inspection or a sewer scope, roof inspection, or any other specialty inspection that might apply to a specific property. In our buyer presentation book, we have a section that talks strictly about inspections and the type of inspections available to the buyer. Make sure your buyer is aware that there's a variety of inspections and they should avail themselves of the opportunity to thoroughly understand a property before they close and own that property. But we're going to account in a timely manner for all money and property received, of course. So if we receive an earnest money check that we're going to deliver somewhere, we're going to copy it. We're certainly going to ask them to copy any checks that they might deliver directly to a title company. We're going to want from the title company any receipts that they have on earnest money that's been distributed, or a wire transfer. We certainly want a copy of that. The Real Estate Commission requires that we maintain records for all account for any money that we receive or our title companies receive on our behalf. Keeping buyer fully informed regarding the transaction. Sadly, this is one of the places it seems to have the most difficulty. We, for whatever reason, just don't talk to our consumers. We should make sure that we're talking to our buyers at least weekly, if not more often, from the time we meet them until 2 or 3 weeks after they've closed on their property. Now, we can't disclose some information in 5.2.1.2.3.4. Buyers willing to pay more than the purchase price. Well, of course not. Although we find often when we get on the phone and talk to agents that represent other companies, we'll find them willing to discuss the price that their seller's willing to take. Well, we certainly want to be talking about that with our buyers. Our buyers making an offer. The offer is what we understand at this point. If they wish to offer more, we'll deal with that in a counter proposal. We're not going to talk about the buyer's motivating factors. The buyer will agree to financing terms other than those offered. That's generally not a big issue, but it could become in play on an owner-carry situation. Any material information about buyer unless disclosures required by law or failure to disclose such information would constitute fraud. Now there's two things here that are going to be important to consider. One is, in most of our offers, we're going to provide some kind of written information from a lender that says these people are qualified to buy a property, whether it's a pre-qualification or pre-approval document. We'll be doing that with the approval of the buyer. In some cases, buyers may want to write a short note to the sellers indicating that they really love their property and would very much enjoy living there for any number of reasons based on schools or decorating or whatever a buyer may want to write to a seller to increase their negotiating position. If the buyer's writing that, obviously they're disclosing it. Moving on to 5.3, buyer consents to broker's disclosure of buyer's confidential information to the supervising broker. That would be me, unless, of course, I represent the seller in a property, in which case you wouldn't want to be disclosing anything to me. You would have to disclose that to the designee, whoever I would appoint in my place, if in fact you needed any help creating your contract. A broker may show properties in which buyers interested to other prospective buyers without breaching any duty or obligation to buyer. What that means is, if we've got a really wonderful property and you've got 3 prospective buyers that could work in that property or want to live in that property, you show it to all 3 of them, first come, first served, and you're not obligated to discuss with any of those folks that there's other people that are interested that you're working with. If it's that good of a property, you're not going to be the only one anyway. 5.5, brokers not obligated to seek other properties while buyers are already a party to a contract. What that means is, once we get them under contract, we don't have to go seek out other properties. Now that's not the same thing as saying that if the buyer wants to make an offer on another property, we're certainly going to have to go write that offer on their behalf. Understanding that they may be creating complications for themselves, that may be a time when we may want to say they might want to talk to an attorney. 5.6, broker has no duty to conduct an independent inspection of the property. Folks, we're not inspectors. We can certainly talk about, in my opinion, the property seems to be okay. However, you need to create an opportunity for an inspection. I'm not an inspector. Make sure they understand that we're not inspectors, and anything that we say about the property, that it's a very nice property, doesn't mean anything. Make sure they understand that. Broker must disclose to any prospective seller all adverse material facts known by broker. The simple example of that might be that it's not obvious, but we happen to know for a fact that there's going to be a new road built behind this house that's going to create a lot of traffic. We need to disclose that if that's something we know. Buyer understands that buyer is not liable for broker's acts or omissions that have not been approved, directed, or ratified by buyer. What that means is you shouldn't be talking about anything that the buyer hasn't authorized you to talk about. Don't go off the reservation and start trying to make a deal for the buyer without the buyer knowing what the deal is. Number 6 comes in play for buyer agency. Additional duties of buyer agents. Number 1, we're going to promote the interest of buyer with the utmost good faith, loyalty, and fidelity. That means we work with the buyer and no one else. We're seeking a price and terms that are acceptable to buyer and counseling buyer as to any material benefits or risks of the transaction that are actually known by broker. This is agency. This is our fiduciary. This is where we become responsible for making sure that they understand to the very best possible way that here's what's happening with this particular transaction. Number 7 is compensation to brokerage firm. There's a success fee. We're going to generally check this box like that. And I often put in 2.8, although there's no reason why we couldn't put in 3.0 of the purchase price, but not less than something, a dollar amount if we wanted to do that. We can put in an adjusted amount and additional provisions. There's a variety of things we can do here, including an hourly fee, retainer fees. We don't normally do retainer fees, but there's no good reason why not, especially if we're going to be putting a lot of effort into a particular transaction with buyers that may be back and forth for many periods of time. So a retainer fee may be very logical and normal in certain cases, in which case we check the box and put in a retainer fee of $500. The amount will be credited against other fees payable to brokerage, or maybe not. Maybe it's $500 that's just a retainer fee credited that's not going to be credited against any compensation we might receive. I'm not going to do that in this case because I represent the buyers here as as their agent in selling their property. Maybe other compensation. We could get them to give us their fully paid for motorhome as compensation, perhaps. Brokerage firm's fee on a lease. Again, not normal that we would do a lease, but if we think that's a place we want to go, we may want to make notice of it. Again, when earned, payable on leases, all these things need to be thought about if we're going to be involved in a lease. 7.3 talks about who will pay the brokerage firm's fee. Listing brokerage firm or seller may pay, buyer is obligated to pay. Folks, I would advise we try and check this as often as we can. It's pretty difficult because buyers generally believe that the commission is paid by the seller. In some ways that's a bit of a sleight of hand because the reality is the commission is built into the price of the house, and in some cases it might make perfect sense for a buyer to pay a commission. As a matter of fact, it might make sense for the buyer to pay the brokerage firm's fee, and we'll discount that on our offer. There's a variety of ways we can go here. Listing brokerage firm or seller may pay, buyer's not obligated to pay. Obviously, that creates some exposure for you if you get in a situation where, for whatever reason, the listing brokerage firm does not agree to pay. Make sure, when you're looking at your flyers and brochures on the MLS, that you understand what the cooperative fee is, and are we reasonably certain that these folks are going to be paying that. If so, it's probably safe to check this box. Holdover period, I normally put 60 calendar days in here. You could make it longer or shorter. The buyer will or will not owe the compensation if a commission is earned by another real estate brokerage firm acting pursuant to an exclusive agreement with buyer enter into the holdover period, blah, 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 blah. If no box is checked, then buyer does not owe commission to the brokerage firm. This is a bit of a change from the historical approach that if our buyer left us and went with someone else and created a contract in the holdover period, that we just would be out of luck if they went and did something else. I think probably we want to check will, and the reason why is because we may have done a considerable amount of work on behalf of these buyers, and they decided to throw us over the bus or throw us under the bus after it's over and want to go now and try and execute something. It's not unreasonable that we try and let them understand that we would like to get paid for our considerable amount of work. Well, that's it for the second section on the buyer listing contract. We'll come back shortly with the next section. Thank you.